Hi everyone, welcome back to my channel. Today's workshop's all about planning permission versus licensing. Now, very often people get the two confused and mixed up. So today we're going to be covering Article 4 direction, planning permission and licensing. Roll the intro. Okay, so we're going to delve into Article 4 planning direction, licensing, and the definition of a HMO. Now, you might want to write some of this down because very often people still get confused between what is a HMO, what's planning, and what's licensing. So hopefully I can help you with that today, and maybe if you write it down, it might stick in, and you can also refer back to it as well if you need to. So first of all, I want to say the definition of a HMO. What is a HMO? Oh, I say HMO, by the way, not H. Which camp are you in? Are you in the H or the H? So the definition of a HMO is a property that's occupied by 3 or more people forming more than one household. Okay? That's just the definition of a HMO. That's not licensing. And it's not planning. I'm going to go through that again. The definition of a HMO is 3 or more people forming more than one household. It's really important that you understand that. So if you have got that scenario, 3 or more people forming more than one household, then that is a HMO. Now, a household is cohabitees, people that live together as man and wife or as partners, civil partners, same-sex relationships, or family members. Okay, dead easy. Now that, if you're living in the house as well and you've got lodgers, then it will exclude you. It will exclude you. So you don't count in those numbers. So you can live there and you can still have 3 or more people forming more than one household. So that's the definition of a HMO. Please remember, it's not licensing and it's not planning. Okay, let's talk about planning permission. You may have heard of something called Article 4 direction, and you may confuse it with licensing, and you may think the two are the same, but they're not. So this is part 1, which is planning permission. We'll cover licensing in part 2. So part 1, planning permission. Let's talk about areas that don't have any planning restrictions, such as Article 4 direction. So if you've got an area that you're looking to buy a house, turn it into a HMO, provided you don't have Article 4 direction, you can turn a house, which is planning class C3, into a small house of multiple occupation, which is planning class C4, for up to 6 sleeping people. Maximum of 6 sleeping people. Now, it's not rooms, it's sleeping people, bums in beds. Okay, I'm going to recap. If you are looking at an area that does not have Article 4 direction, then you can convert a property into a HMO under permitted development for a maximum of 6 sleeping people. Okay, so it's got to be a C3 property into C4, which is HMO. And that's if you don't have Article 4 direction. Now, if you're looking to convert a property for more than 6 sleeping people, then you will require planning permission anyway, regardless. Okay? Dead easy. Hope you got that. Now, areas that do have Article 4. Now, Article 4 direction is a policy that local councils can use in order for them to remove permitted development rights in certain areas for certain things. Now, that's not always necessarily going to be just for HMOs, but you need to check that if you do have Article 4 direction, is it for HMOs? And if it is, then you are going to need to apply for planning permission to convert any property into a HMO. And that's it, really. That's Article 4 direction. Now, if you're marketing to properties that are already HMOs, and if they were HMOs before Article 4 direction was put into place, then they would have been given grandfather rights. So if you're looking at those properties to buy or to do maybe a rent to rent or a lease option, you need to make sure that they do have the correct planning permission. So what do you need to do with that? Well, you'll need to prove that they were operating as HMOs before Article 4 direction came in. So how do you do that? Well, you'll be looking for licenses, AST contracts, and anything that you can put together to prove that they were in fact HMOs before Article 4 direction. So that's Article 4 and planning. That's part 1. Now we're going to move on to part 2, which is licensing. So remember, the definition of a HMO is 3 or more people forming more than one household. That's the definition. Okay? Now the mandatory HMO licensing scheme stipulates that if you have a property that has 5 or more tenants forming more than one household, then you will need a mandatory HMO license. Now, this isn't planning permission, this is licensing. Now, you can't operate your property unless you have the correct planning permission. So you need to do that first. Once you've done that, then you can look at getting your property licensed. So the mandatory licensing scheme is 5 or more tenants forming more than one household. Now, some areas have something called additional licensing. So that's on top of. So any HMO would require a license if your area operates additional licensing. So what does that mean? Any HMO, what's the definition of a HMO? 3 or more people forming more than one household. So that's a HMO. If your area has additional licensing, you will need a license anyway. Okay, clear as mud. Good. So number 1 is planning permission, and it's separate to number 2, which is licensing. Now, in order to get your license, you can go onto your local council's website and download something called the Amenities Standards document. And in there, it will tell you exactly what you need to do to make your property compliant, so then you can apply for your license. And it will tell you the minimum room sizes, it will tell you the minimum kitchen sizes, what fire alarms you need to use, etc. And it's all in that document. So you need to make sure you've got hold of it. And if you're constructing the property yourself, your building team work towards achieving what's in that document. Or if you're buying an existing HMO, you need to make sure that they are compliant, or that property is compliant to what's in that document. And it will tell you everything, your minimum room sizes and everything that you need to know. Now, you also need to be aware that in October 2018, the national the mandatory requirements for room sizes in HMOs for a single occupation is no less than 6.51 square meters. So you need to make sure that if you're looking at existing properties that are already HMOs, then the rooms, the sleeping rooms, are no smaller than 6.51 square meters. Now that is mandatory, so there's no discretion. Councils can add to that. So you may find that in certain areas, your local councils might want more. And that's why it's important you get the amenities standard document, so you can work towards that, and then you can make sure that you're going to be completely compliant. So let's recap. Planning permission. If your area has Article 4 direction, you will need to submit a planning application to turn a house into a small HMO, which is up to 6 sleeping people. If you want to do more than 6 sleeping people, you will require planning permission anyway, called sui generis. Okay, so you can do permitted development up to 6 people. Anything over 6 people, then you need planning permission. If your area has Article 4, you need planning permission anyway. Cool. Then licensing, 5 or more people forming more than one household will require a mandatory HMO license. If your area operates additional licensing, that means any HMO, which is 3 or more people forming more than one household, will require a license too. I hope I haven't confused you too much. Feel free to watch this as many times as you like, and hopefully it's cleared up a few of the confusions you may have had with licensing and planning permission. If I can help you with anything else, please comment below, let me know, and I'll drop you a line. Thanks for watching.